The CJCC is called to order. This is the March 12th meeting of the Criminal Justice Coordinating Council. My name is Pam Weechen. I'm the chair of the CJCC. This will be a hybrid meeting. Due to construction at the courthouse, the CJCC meetings will be held at the EOCA meeting room for the foreseeable future. A little housekeeping for our new meeting space. The restrooms are located down the hall on your left, right before the double doors. I want to pass on some information regarding how we'll conduct our meeting. We ask that all members on Zoom please turn on video if you have it. We ask that all members on Zoom mute their line when not speaking. We ask that you please identify yourself each time you speak. If you are on Zoom and have a public comment to make during the public comment section of the agenda, please use the raise your hand function on Zoom. Recordings of the CJCC meetings are available on the CJCC website after each meeting. Our first agenda item today is a presentation from the Jail-Based Competency Restoration Work Group. Katie, take it away.
Thank you, Pam. Can folks on Zoom see my screen? In here, okay.
You got thumbs up.
Okay. So it is my privilege today to present on behalf of the work group and team of partners who have spent the last several months developing a process to provide competency restoration services to our Douglas County residents in the jail setting. The presentation today will walk through introduce you to the work group members and a little bit about how this work group came to be, kind of revisit the state of competency restoration here in Kansas, and how changes at KDAS have brought us to this point. We'll walk through our process that we are proposing to implement here in Douglas County and share a little bit of our implementation plan so far. So this work group was facilitated by myself and Patrick Schmitz, CEO of Burt Nash. We were joined by Burt Nash staff, Carrie Combs, Dr. Houston, Dr. Dodson, Paul Leffingwell, and Sarah Godinez has kind of joined us now as we're moving into getting ready to launch implementation. She and her team will be kind of integral to the implementation part of this. From the sheriff's office, our work group was Sheriff Armbruster and Major Bunting. The Association of Community Mental Health Centers of Kansas, we were joined by Andrea Diaz. We'll talk a little bit about the role of her organization in a little bit. Our Chief District Court Judge, Jim McCabery, and Director of Behavioral Health Projects for Douglas County, Bob Trainski. So the topic of competency restoration and the challenges that the current processes present for our defendants, our jail staff. That should be better. Okay, sorry. So I don't really know how to do this. Okay. So the topic of competency restoration and the challenges that the current processes have created for our defendants, our jail staff, and our courts should not be new to folks in this room or people in this community. Several of our partners have been vocal champions about the need for improving the system. In the spring of 2023, these conversations among our partners, primarily our sheriff, our district attorney, and Burt Nash staff, about how communities can improve and have an impact on their local restoration process, were the formation of this work group. We had a kickoff meeting last September that we were joined by Andy Brown of KDAS, the program director and the superintendent from Larned State Hospital, staff from the Association of Community Mental Health Centers of Kansas, and our local work group. And in that meeting, we got kind of the skeleton and guidelines of what KDADs have put in place in order to make this a possibility for local jurisdictions and communities. Following that meeting, this work group really met in earnest to figure out what and how we could stand up a local restoration program in the jail. These were meetings that I just had on my calendar that were either full work group meetings, or subsets of work group members that kind of focused on different tasks. And on the January 18th meeting, we had our district attorney, our deputy district attorney, our chief defender, and the mitigation specialist from the bids office join our work group, where we presented the kind of where we were at, what we were thinking might work, to get their feedback and questions that we may have missed, or things that we might not have thought about in the process. So as kind of a reminder of how this should be a reminder for most folks here, but how competency works currently in the state of Kansas, when the question of competence to stand trial is raised, a judge during criminal case proceedings, a judge will order a competency evaluation, which for us locally, that is generally completed by Sarah and her staff or her team of staff at Burt Nash. Those evaluations are to be completed and returned to the court within 60 days. If from that evaluation, the defendant is deemed incompetent to stand trial, a judge will enter an order to require restoration of competency. Competency restoration has generally been provided in the state hospitals, or by a state facility, which in this process, we're usually talking about Larned, although there are a couple other facilities in the state that have at times provided that. But over time, not just in the state of Kansas, but across the country, what we're seeing is that the need for inpatient restoration beds has far exceeded the availability of those beds. And that has resulted in long wait times. Generally for defendants, they are waiting in the county jail. And it's a process that generally does not work well. So these wait times have varied. We generally can expect to see folks waiting for over a year. About 14 months is what we've seen most recently. Recent collaboration between Larned and Osawatomie State Hospital has resulted in Osawatomie has had some extra capacity to take some of the lower risk cases, lower need cases, generally misdemeanor cases. They've been taking some of our residents, at least I know, have been going to Osawatomie here more recently than Larned. Once restoration starts, the restoration process is required the clinician is required to provide a report back to the court about the status of the restoration within 90 days. Has the defendant been restored to competence, or is there a significant degree of likelihood that they will be restored within an additional 90 days? If competency is not restored within that 180-day period, the court is directed to consider civil commitment or other means of case resolution. In an effort to meet the needs of competency restoration across the state and to reserve the use of Larned inpatient beds for the most severe cases of competency restoration, KDADS has begun to look at different options to meet some of the lower level needs. The first of those was in the spring of 2022, KDAD started offering a mobile restoration program in several counties. Douglas was one of those counties. So in that program, a defendant they were determined to be incompetent to stand trial. KDADS and Larned staff would review their evaluation, generally consult with the staff in the jail. So they consulted a lot with Paul Leffingwell and his team from Burt Nash. And they would determine whether or not the defendant was eligible for the mobile restoration program. And in that program, Larned provided a clinician that would rotate, they would visit the jails where they had defendants to work with. The program criteria for this was very strict, and it limited the availability of participation. Usually, participants were deemed ineligible if they were not medically compliant. And for a lot of folks in this population, that can be a challenge. So while this program had limited participation, it's a very successful program when we have had folks, go through it. So after that program launched, KDADS and Larned staff began talking about the opportunities for how could local communities through their community mental health center or their CCBHC, how could local jurisdictions provide competency restoration? Which was that was a task of this work group. That required some statutory text changes, some different court orders in order to make that available. In a lot of those documents, it's referred to outpatient restoration. In this context, outpatient simply means restoration is not provided in the state hospital or in a state facility. So it's not necessarily the same as when we think about going to Burton Ash for outpatient therapy. So outpatient is just more broadly referring here to not being provided in the state hospital. These KDADS has, similar to when KDADS began reimbursing sheriff's offices for days that defendants were waiting in custody. KDADS has also contracted with Wheat State Health and working with the Association for Community Mental Health Centers to provide reimbursement to the CCBHCs or CMHCs who are providing these services. So from a fiscal, I feel like it's important to share that the fiscal lift of this is generally coming from KDADS. So this is what created the opportunity for this work group to come together, was these changes in order for outpatient restoration to be made available. Before we talk about the local changes or what we're proposing to implement, our work group felt it was really important to kind of ground that there's not a model of how this should look, how this should go, what's needed. It's going to be up to whatever resources are available in the community and how the community can best leverage resources that they have. So early in these conversations, when we realized different places were considering doing different things, this idea that there was no kind of plug and play model that we're used to for when we're implementing new programs, really gave our work group permission to be intentional and thoughtful about what would work, what would best serve our defendants, our court, and our staff. So we kind of want to share that to kind of caution about, well, such and such place is doing it this way and such is doing it that way. Throughout this planning process, many of our partners or many of our work group members were touching base with their peers or colleagues in other parts of the state to say, well, how are y'all going to do this? Or what are y'all thinking about this? What challenges have you experienced? And throughout that process, that reinforced this idea that these are likely going to look different everywhere. Those conversations also really reminded us that Douglas County is uniquely positioned to be successful in this endeavor because of the resources and partnerships that we've developed over time in this community. This community has, as no surprise, but as a good reminder, has invested significantly in mental health services over the years. And we believe that this program is one of the places where we will see those investments come to fruition. This program would not be possible without the commitment by the sheriff's office to provide mental health clinicians in the jail, and not just one, but a team of clinicians that are fully embedded into the operations of the jail facility. And by growing service array that our CCBHC has committed to continuing to provide here in the community. Our CCBHC in particular provides our staff of competency evaluators, which is not something that every jurisdiction has available to them. They also provide the staff to the jail that are embedded in the jail. And as we've seen Burt Nash continue to expand their service array, that has just broadened the accessibility of psychiatric services in particular to support these clinicians in the jail. And through that, because we only have one provider, we have our primary behavioral health provider in the community, working with folks prior to when we see them in the justice system and when we see them in the jail, working with them in the jail, and then being able to transition back to services after their release. We have the opportunity to create a more complete continuum of care. These partnerships and resources have become the way we do business here in Douglas County. And this is not the case in every jurisdiction. So it was important for our work group to share that, to kind of remind folks that we feel like we are in a really good position for this program to be successful. This next slide might be a bit of like it's a lot to work with. It's the best I could get, the closest I could get to like a logic model. But the big change here, so the biggest difference that we are proposing is here at the initial assessment. So a judge would still order competency evaluation. And part of that, Sarah and her team generally return those evaluations fairly quickly to our court. What we are proposing to add is the opportunity for that assessment to include additional input about where a defendant would be best served, inpatient restoration or in the outpatient or local restoration program in the jail with Paul and his team. So that is the biggest change here. What happened here, I probably could have added a funny graphic to highlight that, but we feel like this gives the court more information up front on the front end to make a more streamlined decision and a more informed decision about where a defendant would be best served. Particularly if they're amenable to outpatient treatment or to the outpatient restoration program, this allows that defendant and Paul's team to kind of start working a little bit more quickly. If we start someone in outpatient, there is a chance that while working with Paul, they may not make significant progress and that they may need to go inpatient into Larned. When that happens, so that's here, I've lost my cursor, but on the second row, so assuming everything goes well, Paul's team starts working with them, they report back to the court within 90 days, whether competency has been achieved or whether an additional 90-day extension should be requested, and then competency should be restored, ideally within 180 days. If at any point while they're working into outpatient, the team feels that inpatient restoration is needed, there's a process that Larned has built out for that. So the clinicians would report back to the court about that outpatient is kind of not as successful as we thought, and they would be referred back to the wait list for Larned. An important point in this process is that placement date back to Larned is based on the original order date that the judge ordered competency restoration. So it's not, if we get to day 80 of 90, that they're placed on that we've lost 80 days. It's based on that original order date. So we really don't lose any time if a defendant may end up needing to go to Larned. If a defendant is initially recommended to outpatient, we have seen at times, and we've seen this with the mobile restoration program, that a defendant is not necessarily initially eligible, but while they're waiting for their bed date at Larned, they've become compliant with medication, they become willing to engage in treatment and have actually been able to go into the mobile program and successfully complete that. And we anticipate something similar with some of the defendants as well. And so we also have the same opportunity if they're initially ordered to go inpatient, but become amenable through their work with Paul and his team, that we could also go back to the court and ask for them to be ordered into the outpatient program. So just because they start in one place doesn't mean that they will stay in that, depending on their needs. There will still be a need for people to go to LARN. This program is not intended to replace the need for that. The idea is that for folks who are not at that necessarily high severe level for inpatient, that we would be able to serve them more quickly and locally. But there will still be people who need to go to LARN. The second part of this process is that there has to be an option for medication over objection. It at least has to be an option in order for these programs to be successful. This is oftentimes what differentiates going to inpatient or going to a state facility versus providing these services in the community up to this point. So as Larned and KDADs were working to make these opportunities available to communities, they developed in a template court order to allow jurisdictions to consider medication over objection. Our work group spent a lot of time talking about this. And what we spent a lot of time talking about kind of who's the best position to make these recommendations to the court, who's the best to how and where and by whom would this be administered if it was ordered. Where we kind of landed is that once someone is ordered to outpatient restoration, Paul's team would meet with them. We have folks who are on a medication regimen and they're taking it and it's working, and we would just continue their medication right now. In those circumstances is provided by ACH, which is the medical provider in the jail, and that would continue. If they're not compliant with a current medication regimen or the medication doesn't seem to be working, we need a different evaluation, then Paul's team would reach out to the psychiatric staff at Burt Nash. So Dr. Houston or Dr. Dotson's team to kind of come in, help evaluate, and if necessary, provide the information to the court, initiate that medication over objection order. Our clinical experience and expertise on this work group and information from Larned suggests that this is likely going to be minimal. Clinicians generally, when they're working with folks kind of as regularly as, and this is a benefit that we have of having a team fully embedded full-time in the jail, there's a lot of access and opportunity for those clinicians to engage and work with these clients. And we think this will be minimal, but we feel like it's a really important component of the process that we need to have available. If we have to administer medication, the safety of everyone involved would be prioritized. So might be controversial, but this was where we spent the bulk of a lot of our work, was thinking through how do we do this? How does this look in practice? So thinking about implementation, we had targeted kind of a hard launch date for new referrals for competency to begin being available to outpatient program on April 1st. We will continue to meet even after launch. We have meetings set out for the next several months to monitor kind of how this is going, what challenges are we running into. So this work group, we anticipate will continue to meet for some time. KDADS has not necessarily provided any kind of target measures or things that they're looking for. So these were some of the things that our work group thought were important for us to kind of track and monitor our impact. Some of these are already being tracked through Paul and some of the sheriff's office staff as they provide information to KDADS currently. But looking at how many folks are referred, how many referrals do we get for competency restoration and inpatient versus outpatient. Looking at the length of time, for our outpatient, referrals, what's the length of time between when we get that order and then when Paul and his team are able to start that treatment process? How long do folks spend in the restoration process? Do we see a difference in length of stay in custody? And then thinking about time to case disposition. The outcomes of the outpatient program. So when Paul and his team are working with them, how many of those folks have competency achieved or restored? How many of them need to continue to be referred to inpatient? If we have to get court orders for medication over objection, tracking, are there any and how many adverse outcomes following medication over objection? These would be things like adverse reaction to the medication, any injury to staff or to the patient. We anticipate that this measure would start and stay at 0. If defendants go through competency restoration, how many of them may decompensate and need to go through the competency evaluation process again? We do know that happens when folks come back from the state hospital sometimes. So do we see a difference in that going through the outpatient program? And then how many folks who are initially referred inpatient but were able to kind of gain rapport and maybe work with them outpatient? So these were some of the kind of first measures that our work group was thinking about kind of tracking. We do have folks. Paul has been spending time over the last few months kind of culling the list of people who are waiting for restoration to see if any of those individuals might be good candidates for this program. And so we're working on a process for when we do find individuals who would be good candidates for him and his team to work with, kind of how do we get them engaged in that program or that, or change the court order for them to be able to do that. And then we have started talking, so I've already kind of have on our radar of different stakeholders that we'll need to ensure that we're kind of worked with, shared information about how this program works. So right now, Paul and I are kind of already slated to join one of the district attorney's staff meetings to share about this. So we'll just need, bids for sure, and defense bar and potentially the judges. So we're aware that this is on our radar to engage stakeholders. And as those opportunities arise, our work group as a whole is willing to kind of go on the roadshow however that makes sense for people. This is my last slide. So I met most of our work group members. So we have Sarah is here with us, the sheriff, obviously, I think online, Patrick, I saw Patrick online, and Andrea from the Association of Community Mental Health Centers. So they are available. I think I would turn this over to our work group members for anything else they would want to share or questions that folks have.
This is Pam. I have a question about the medication over objection. What does that exactly mean?
All right, I'll take it. We anticipated this being the question. So long and short of it is that what we're trying to do here is we are from a state standpoint and a county standpoint, we are inventing the wheel. However, the work that we are looking to get done is simply we're trying to shift that work from a waiting bed in Larned to our jail. And so specifically the treatment that they would receive in Larned, we are trying to move that local. And when it comes to medication over objection, the question simply becomes, to just speak in very plain terms, you have a person who has been deemed incompetent to assist with their defense. A prescriber has prescribed a specific injectable medication. That person refuses or declines that medication. As it stands today, we are unable as a sheriff's office, as a jail, to force that medication for that intentional purpose. What this creates is a place for a judge to step in and say, I understand that you do not want to take this, do not wish to take this, but the medical provider is saying you have to do it in order for you to help with your defense. This has to happen. Therefore, I'm signing an order saying that this is going to take place. From a logistics standpoint, from the point where the judge orders it, it will then become the work of the sheriff's office, as well as the other team members, the clinicians, the mental health clinicians, and the medical providers. But what it actually looks like, and this is the question everybody wants to know, is what does this actually look like happening inside our jail? Here's what I'll tell you, is that a person, we would work, obviously, we work with people every day just to get them to take showers, just to get them to clean their cells, just to get them to go to a program or to go and see a medical provider. We work with them every day. This will be no different. But at some point, once that system is exhausted, we will inform them that this is going to happen. And what we would do as a jail staff, that would mean that we would assemble our disturbance control team, who are the professionals, the experts in this field. And we would basically take them into custody. And what that would look like would be physical restraints, and then what we call a wrap system, which is I don't mean this in a degrading way, but it is basically a tortilla that you wrap this person into that secures them, and then what we would do is we would allow the providers to go ahead and introduce that injectable into their system. And then we would monitor and everything. The logistics of it are quite simple, in my opinion. Now, here's the caveat. What if this person absolutely wants to fight like a caged animal? To be honest, we will back away. We will, then that bed that Katie talked about, that will always be waiting for them at Larned, would then be utilized, because we're not going to risk their safety. We're not going to risk our safety. But in speaking with Larned State Hospital and their teams, rarely does it come down to the fact that they have to physically fight a person to give them their medications. The fact that the team is there and assembled, the paperwork is done, and the client or the person who is receiving the injection knows that this is a known quantity and it is going to happen. Almost always that person allows it to happen on their own because they want to have some control over it. And that's what is our hope. So I anticipate fielding a round of questions of how this will look, and we're not trying to hide a thing, but
Worst case scenario
is somebody who is violent to the point that they are willing to hurt themselves or us. And in that case, we would back away and allow the Larned State Hospital to handle it. But up until the point where we have to simply take somebody into physical restraints and give them an injectable, we are perfectly comfortable, because that is the kind of work that we are trained to do. And we see the absolute value in doing it locally, as opposed to waiting 12 to 14 months to have it done in Larned. So I probably created more questions than I answered, but that is.
No, I appreciate the answer.
Yes, and I appreciate the question.
Jay,
Yes.
I was like, that sounds horrible to
It-
me. It sounds absolutely horrible to
Right.
me. But we're talking someone that has a mental break or mental disability.
Yeah.
Something that's going on, right? That
Right.
is, they're not functional,
Yeah.
right? Because as a person that is functional.
Right. So let me,
And I guess where I'm a little bit concerned with, you're wrapping this person out,
Uh-huh.
you're doing all of the, you're just.
Yeah.
Yeah.
yeah, no,
So, yeah.
absolutely,
So, sorry, Tim,
absolutely fair.
but yeah, so I'm struggling with that.
And,
Go ahead.
and what you're thinking is exactly what everybody else is thinking. And so, but what I want to say two things. The one is that, when one thing I've learned over the years is that you can't use rational thought to describe how an irrational person was thinking or reacting. And so it is very hard for us to wrap our brainstems around the fact that we're going to actually have to physically engage with a person in order to do what we believe to be what is in their best interest. But what I will say is that, and knowing, having the lived experience of working in the jail, and knowing the people who are currently on the waiting list to go to Larned, or the people who in our past who have been on that list, I know simply that, I don't think I can think of one person who would have physically fought us to do this. But even if it had been to that situation, I don't believe any of them would have been to the level that we would have not been able to handle it ourselves. However, the rap that I talked about, the Lawrence Police Department uses that rap, and I would say they bring somebody into custody and bring them to our jail in that exact piece of equipment once a week. So this is not, and these are people who are physically fighting and have had a mental break to the point where they don't understand what it is that's even occurring. What we've found is that typically people, once they've come into jail, they've decompressed, they've settled out. Some of them start back on their medication, some do not. But even then, they are a much different person by the time that this order would arrive, because we're talking 30, 60 days from their arrest. It would be some time before that order even got to us. So we would have a rapport and working relationship with these folks. But I want to also stress is that when a person, and I'll make one last thing. So when a person who is in custody wants to come out of their cell for something that is a little bit unique, they are typically placed into restraints while they were in their cell. So like, we have a door that opens up where a food tray slides through. So that door is opened up, they place their hands outside, they're handcuffed. And then once we get in there, we put leg restraints on them and then we move them because they're easier to control if they do become violent. This process would only be one step further in that we would place them into something a little bit more restrictive, I guess, if that is a word, restrictive. And therefore it would just allow us an opportunity, the clinicians an opportunity to do this work. So, but the bottom line is that we understand the fact that citizens have concerns about this. And so therefore, we want to do this in the most transparent and open way that we do it. But ultimately, there will be some physical restraint that has to happen. But like I said, this is nothing different than what is happening in Norman. This is a bit more of a, it is in our backyard. This will happen in our backyard. As opposed to it happening in a facility half a state away, where we have no idea what it is that's actually happening and we don't have a picture of that. So we're just basically bringing that work closer to home.
And the hope is that by being able to do this here, rather than having somebody sit and wait for a year or more than a year to go to Larned, where they may also need this kind of intervention during that time frame, they can further decompensate.
Right.
If they're not taking their medications, and then that process becomes even more problematic down the line, or it's more time consuming down the line when they finally get to Larned. Their mental status may have deteriorated to the point where it will be a more invasive or a more problematic process.
Thank you for the answer.
Yeah.
I had another question. This is Pam again.
Can
I don't understand the timeframes. Like, do you only have 180 days ever? Or is there not?
I can talk anecdotally, Court may want to chime in on this. Anecdotally, and I'm thinking specifically about a person who is currently in our custody, who is up on a murder charge. That person, it would take them probably 30 to 60 days into their from their first appearance, from their arrest first appearance, to where their attorney, and most of the time this comes from the defense, where the defense says, my client is not able to assist with their defense. We need to order, judge, can you please order an evaluation? So from that point, the judge will order an evaluation. Our team is working to try to do the evaluations in-house instead of sending them to Larned to do the evaluation, not even the restoration part, just the evaluation. And so that takes, I don't even know what that process takes, probably 30 days to get them evaluated, get them back in front of the courts. So I would think at the point where an order would be signed for a medication or rejection, I can't imagine happening before 90 days into a process where somebody has been arrested. I suppose it could happen quicker than that, but I would imagine it would happen there or later, would be my uneducated executive branch opinion.
Those timeframes of like the check-in where the court needs to get an update or some certification that competency's been restored or not. Those are timeframes from once the clinical staff has started the competency intervention and started the restoration. So, if someone's not cooperative with Paul or doesn't want to engage with Paul's team for a little while, that kind of time clock doesn't start until the actual process of the restoration program starts.
Nobody's gonna be ordered to receive medications over objections until there's been a finding that they are not competent.
Okay.
And that, so that, just getting to the not competent in this district, 30 to 45 days from the time that the issue presents itself, the order's entered. Now, I'm sure I don't know the clinical side, but I'm sure there's instances where right away, somebody can make that determination, but that request has to come back and be presented to the court for the order to come forward. I'm not sure on the 180 days what that references, other than there's 2 90-day windows that a person has to be evaluated for competency. And if that's a continuous period, and at the end of that 180 days, the report is, this person is not likely to be amenable to restoration of competency, we take it down a different track other than the criminal track. But there's no limitation. If you get restored to competency in 90 days, and you're fine, and then your competency becomes an issue again, you can get back into that cycle. And then, but after 180 days, if we haven't gotten you out of the cycle, we're gonna send you on a different track.
Yeah, I'm gonna turn my hat around. I played different roles at the table. And I asked Patrick and Katie to be part of this process, Sheriff Armbrister to be part of this process, so that the lived experience perspectives at the table. So I am a person with bipolar disorder. I lost 5 years of my life to my illness. I lost 10 years of my life trying to put that back. And as I sat through this process, and I don't speak for all people with mental illness, I don't represent NAMI in this conversation, but I want everybody to know at the table that, to Sarah's point, the harm that will happen, not might happen, but will happen, by a person sitting in jail for a year without medication, proper intervention, and the opportunity to start to experience relief of symptoms will be more damaging than anything else that we're talking about at the table here. And so I want people to know, if you weren't involved in the process, that I've sat through this process, and I've asked myself and I've asked people in the work group about procedures and process or what have you. I've been on this council for 7 years. I started as a community member. This is an example of how shared pain around this table, as we've watched people suffer, has turned into shared purpose to make this better for the person at the center of this. And what would happen in the jail is no different than what happens at Osawatomie every day. It's no different than what happens at Larned, and will happen at Larned if we transfer that person. The benefits of this are, you have a dedicated local medical team that includes a psychiatrist, that includes people who have experience with this type of procedure because they're doing it at the treatment and recovery center. And this process that we spent 6, 7 months in working at just offers such a better alternative to the person who's in jail and all the human beings who are connected to this person. In my role as Director of Behavioral Health Projects, I've taken calls from the mother, the father of the person who's in jail, as has everybody around this table, talking about how they're suffering, how the process is failing them, the lack of justice, the lack of human rights. So I think, again, my personal opinion, wearing that other hat, is we need to, I think, be very grateful that as a group of people around this table, we've come to a point where we can actually do something about this. I listened to Sheriff Armbrister 2-3 years ago testifying to the legislature about this, and describe what it's like for the human beings who are in our jail who are stuck there because of this. This has the potential, from my perspective, to be one of the most significant things to happen in our justice system since we started doing this work together. 8 or 9 years ago. And I just wanted to put that at the table because I'm a person who sits and say, there before the grace of God go I. I have the luxury to be here, to be in this community. There are just too many people who, because they don't get the right treatment, and they decline and they lose competency and they're failed by the system, just aren't going to get better.
Whatever you want to call it, luxury or otherwise, it's a benefit to us to have Bob Transky, who has been the motivating force, at least in my, and there's a lot of credit goes around, but Bob's passion, experience has been tremendous. This is one of those very few instances where you can say there's almost no cons and there's nothing but pros to the option. And at least as somebody who has watched what Bob has described for a long time happen, not just in this community, but elsewhere in this community, has found a darn good option for us to explore.
This is Commissioner Reed, I really appreciate this presentation, and there's a lot to chew on, and Bob, thank you for your comments and articulation of why this is so important and has the potential to really allow all the people around this table and on Zoom with us and the public to see change and action over time. And it's a tangible opportunity, I think, to disrupt the dysfunction that has been happening at the state level and the sort of natural order of things as they have been for so long because of those impacts at the state and what people around this table have been feeling maybe like they don't have much power or opportunity to control or change. And the work of this group shows to me that there has been some really tangible outcomes of what we can do to not accept that delay and dysfunction that is created by lots of things at the state level. And to, you know, the one difference that I would say, Bob, exists between what was described that can and will happen here in Douglas County now, instead of at Osawatomie or Larned, is that the clinicians and the jail staff and everybody else that is involved with the defendants here have a tendency or a higher likelihood of knowing those folks and having history with those folks and more potential for rapport. And that in and of itself is, I think, something worth celebrating. And I also think the fact that, like, we can and are willing to talk about this process in detail and to try and be clear with people about what this will look like in the context in which these situations may occur is important piece for public education. And it also, like, that's what accountability looks like. That's what all of us being willing to say, this is my role and responsibility to this process, and this is how I'm going to try and make it better, work better for our own systems and functioning, and the safety and well-being of practitioners along with the defendants that are subject to these state laws and processes. So I just want to appreciate it's a lot of tough conversations that I know just got, you know, cumulatively sort of boiled down for us by Katie. And Katie, I think you did a really nice job of summarizing what I know was a lot of depth of conversation and sussing out of what different things look like so that we can answer the question of how and why when people ask us.
I wanted, I know Patrick is in Topeka today, but I wanted to check in, Patrick, with you or with Andrea, if you guys had anything you wanted to add.
Hi, Patrick Schmitz. Katie, I think you covered the work group progress better than I could have ever hoped to have it done. So thank you for that, and I appreciate the conversations. And I really appreciate the partnership and the willingness of everyone to come together to yet again kind of be the leader in the state on something that nobody else has yet embarked on. And others are talking about, but really nobody is where we're at And we know that as we go through this process, we'll continue to learn and adjust and adapt. But we're just really committed to this work and really appreciate everyone around the table and the support from KDADS to make it possible, and the association's role in making sure that that happens. And then Andrea will take what we learn and help others implement that. Again, it'll look different in every community based on what they have in their resources. So I just continually reminded how fortunate we are to be in Douglas County, and that I am to be in the role I am, that we just do things differently because it's what's right for people. So thanks, Katie, for your leadership with me on this.
Hi, this is Suzanne Valdez. I am very excited about what has come to be, I think, an amazing way to, sort of engage the community and restore mental health. From a prosecution perspective, I just want to point out a couple things. We cannot go forward with prosecuting an individual who is not mentally competent to aid in their defense. We don't want to do that. We can't do that. And so this will enable us to ensure that if we're going to hold people accountable in the criminal justice system, that it's done in a way that is done correctly. I mean, obviously locally, because the state's not helping us out, but quicker. So I just want to agree with everyone on what's been said. And then the other thing I want to say is that we've had, once someone is restored to competency, we've had amazing, just that individual, just the turnaround. We had an individual who was charged with a very serious crime, who once they were restored, ended up in behavioral health court and graduated and had the case dismissed. So not only is it prosecution, but it's also alternatives. Is there any way that we can go about having accountability without having that individual who obviously has mental health issues that may have caused the criminal activity? Can we do something other than put them in the criminal justice system? And we already have those resources. So I think that is amazing. The other point I want to make is that with this process being done locally, is that we're going to have victims and survivors and their families have justice quicker. I can't tell you the number of times that we have to let the victim or the victim's family know that the defendant, the person who's been charged with a very serious crime, is just not competent. So they don't have any closure either. So I think this is good all around, and I'm very, very pleased that I think we're gonna be able to get this off the ground, and I'm happy that we all came together to make a difference in our own community, because I think that's what we're gonna start to see, is that we need to have our own solutions.
Thank you. Do we have any other? No? Thanks, everybody, for the input. It was great. Our next item is a CJCC bylaws work group update, and that's that you again, Katie.
It's not gonna be after this meeting, as I'm about to introduce you to your work group. I'm just gonna go through a couple of slides. I tried to give, there's a copy of, the draft charter when we met last month. I have some. We'll read through while I figure this slide out. When we. I'll try again. When we met last month, we received the report from JMI. And I'll fix this because Carrie can see that. Okay. Did I lose everybody on the screen? When you're done before. If you're on Zoom, can you tell me if you can see that?
It's Carrie, I can see you. Oh, I cannot see it.
One can, one cannot.
One more time.
I can't see it, Katie. This is Robin.
Okay. They're messing with me.
There we go.
Okay, what about?
Now I can see it.
Okay. 4 years of Zoom meetings and options. Sorry, technical challenges. Okay, when we met last month, we received the report from JMI about, the assessment of the CJCC in alignment with national standards. One of the things we talked about last month was, that, kind of forming an ad hoc work group, to work on revising and, reevaluating bylaws of the CJCC. There was a set of questions that a lot of, that I had sent out to folks, for feedback around not just the report, but also what does this, what would be important for this group, the perspectives, the questions particularly for related to forming a work group around the bylaws were these two: what characteristics or perspectives do you think are important for work groups on this work group, for members on this work group to have? And what does success look like for this work group? So I received feedback, I've compiled that, I worked with, Christy, at JMI, to kind of cull this and, pulled together. So we have a work group pulled together. So we're going to introduce you to those folks today. We also, that work group met last week, 2 weeks ago, sometime on February 27th, whenever that was. And we worked through a charter, which is part of the handout today. So we wanted to review that with you all, and for you all to kind of give feedback to these work group members, and essentially kind of let them, does this feedback reflect what the CJCC would like to see from this work group, and kind of empower this work group to go forth and begin working on the bylaws, on revisions of the bylaws. I'm not going to read all these slides to you because it's in the handout. But the members, based on feedback received, the members of this work group are Sheriff, our District Attorney, Brad Finkeldye from the City Commission, Shannon Reed on the County Commission, Lori, who's CEO of DECA, Jessica Glendinning, our Chief Defender, and Doris as our community representative. The charter, I'm not going to read this, but what we wanted to, what we hope is an accurate reflection of feedback that you all have provided is reflected in the purpose. So the purpose here is kind of, this is essentially what this work group is being asked to look at, and coming back to you all with recommendations for revised bylaws. There's a section, I kind of had to break this out for into several different slides, but in the draft charter, we've laid out responsibilities of the work group members, which are here. Not going to read this. Of staff, so myself and Christy from JMI, and our role and what we are responsible to the work group members to do to support them in their work. And then the work group brought up and would like to kind of ask that CJCC members, as we go through this process, we don't know quite what this will look like, but these work group members will be reaching out to CJCC members as they're working on things to seek feedback, and we would ask that you engage with them and provide feedback, particularly along the process, rather than at the very end, they've done all this work and say, wait, never mind, we don't actually like that. So the primary ask of CJCC members by members in this work group is to really, if you hear from them, provide feedback, give thoughts, and that sort of thing. I would turn this part over to the work group members. So here, so we have Doris, we have the Sheriff, Commissioner Reed, DA Valdez, and Jessica. Here in person, we have Lori, joining us on Zoom. So I would turn this over to you all if there's additional things about this work group that you want to share. And if there's feedback from the CJCC that we need from this work group. Sheridan.
No comments from the work group? Any questions from the?
I mean, I'll just kind of throw in my 2 cents worth. I thought the meeting we had, where we convened on the 27th, I think, was really productive. I think the JMI's assistance that, has been given to us and their direction, they've worked with lots of CJCCs around the country. What I took from that was, in our conversation with Christie, is that, every CJCC operates a little differently. And that's good to know, so we can kind of create what we want to do. I think that one thing that I stated during our meeting, is that, we've undergone, since the CJCC was originally created, and kind of has evolved, certainly in the last 3 years that I've been here in office, we've just seen so many changes. I mean, I came in 2021 where there's literally a shutdown with COVID. We've seen mental health issues. We've seen lack of budgets. We've seen really the criminal justice system, really trying to change and to react and to do what it can in light of all of the things that we're dealing with, not only nationally or globally, but locally. So I think it's time for us to really sit down and through this work group and through us reaching out to everyone who's involved in what we're doing, to think about how we want to go forward as a CJCC. And so I think the idea is that we'll have some direction, some guidance from JMI, which is going to be very helpful. But I also think we're on a pretty quick timeline where we really want to get this moving. We don't want it to languish. And we want to have at least some ideas presented to the group sooner rather than later. And that's just my perspective. But I thought I'd throw that out there.
In addition to that, perspective, which I love, by the way, is that we're gonna just try to make sure we streamline the process. Make it very expedient, and the expectation will be that, none of us have time to work on it forever. So we just don't, we don't have time to work on it forever. And so the hope is that we can be very collaborative in this process.
Lori, did you want to chime in, not to put you on the spot, but just to give you a chance if you wanted to add anything?
I think the only thing I would add is we are on a quick time frame, so we will likely be asking for feedback in real time, and we would appreciate responses as quickly as possible. We don't want to have meetings or put meetings on hold because we don't have feedback. So we have a very quick timeline, a very quick and aggressive schedule, and our progress depends on you all helping us out. So we would appreciate that. Thanks.
Well, thanks for the update and appreciate the work of the work group. We want to give an opportunity for CJCC members to provide updates on their agency, and also to, if you have any suggested agenda items or topics for the next meeting in May. Do we have any updates or suggestions for topics for the next meeting?
I would expect probably an update from that bylaws work group. I would expect that to be a placeholder for the agenda in May. But not sure if there's other things that folks have for that meeting.
I'll just say speedy trials now, by statute. So there's statutory speedy trial and there's constitutional speedy trial. With COVID, that was all suspended. The statutory speedy trial was suspended, and I'll let Judge McCabe chime in on the court's perspective. But as of March 1st, the speedy trial is back in action, and the calculation of that is based on arraignment. So you're 180 days, it's 180 days if you're out of custody, 150 days if you're in custody. And that starts
to tick, no matter who's in the jail on March first. So we have added the speedy trial, calendar, if you will, to our electronic case management system. And it's gonna be interesting to see how this is all going to play out, because the trigger starts from March first. And so we're gonna see a lot of activity on trying to get cases, set. So I think it's gonna be pretty busy, in the courthouse. I don't know if Judge McCabe has a different opinion of that, but that's kind of how we're seeing it.
I think everything Suzanne Valdez said is correct, and the court's doing everything we can to make sure we've got courtrooms available for trials to go forward. One reason I was late today is I was running my criminal docket, and it takes more time to calculate who am I attributing speedy trial to, and we set a lot more jury trials because that's the best way to keep everybody moving forward, so. To be continued, and we'll see how it unfolds.
Question on that. If a person is currently in custody on March first, does that calculate retroactively back to their arraignment date? Or is it only, okay, very good.
Everybody starts, it's like the land run.
Yeah.
Shot one off, everybody's starting. Here we go.
Okay.
So Jay, if you all have questions about your roster, I mean, thankfully Gary Bunting sends we know everyone who's in your jail. So just let us know and we'll make sure that we're on the same page.
Thank you.
Well, thanks for the updates.
One more update. I just want to make everyone around this table realize the process of bringing mobile crisis response online and the crisis line an alternative to 911. There's a process going on right now to kind of optimize alternative 911 response through those programs. So April 17th, headquarters, Bert Nash, Police Chief Lockhart, Chief Llewellyn, we will be briefing the county commission on the progress of that process. And then I think a week later, there'll be a briefing to the city commission as well. We just make this table aware of that because that will be a venue for really sort of getting up to date. We have a good solid year at least of data on each of these components. And it's likely as we move forward, as we've shared with this group, that convening a table to focus on the performance of the behavioral health crisis system is probably a good idea that we're going to continue to push so that this group can stay focused more specifically on justice system issues. But, mobile response was a work group of this group. So we're trying to figure out how best to configure that ongoing transparency and accountability for crisis system components. So again, April 17th, a study session with the county commission, and shortly thereafter, I don't know the date, city commission briefing on safe and secure communities as well.
Thanks, Bob. Does anybody else have anything for updates? Do we have any questions from the public comment? Do you have anybody online?
Yes, Pam, I'm gonna move Ellen over.
Okay,
Ellen, this is staff. You need to accept my invite. To be able to unmute yourself.
Great. All right, so I have a couple concerns. I heard that adverse outcomes were expected to be 0. I'm concerned about medical monitoring of patients receiving psychotropics, as well as the present danger, which I didn't hear expressed in this meeting, which is the fact that psychosis does cause brain damage. So having someone incarcerated for a long period of time without access to adequate mental health care, if they are psychotic, will cause brain damage or can. That's a very high risk. So I do have loved ones with severe psychotic illness. What I've seen in the community concerns me. I'm on healthcare information releases for someone I care about deeply because he can't always advocate for himself and he doesn't always understand his doctor's instructions. So I see you estimating adverse outcomes at 0, and I don't understand that. because I am familiar with the dangers of psychotropic medicines. Now, I heard the sheriff speak about what they do to people in the jail, and I feel that that's very necessary honesty about what happens to people in this system. And I think that we need to be honest about what damage psychotropic medicines can cause, because you have a harms, you have a lot that we're looking at. Like, what is the risk to someone who doesn't receive mental health care? Okay. It's possible brain damage. Okay. Then there's the right to speedy trial. And then there's the risks of these medicines, because I have watched someone develop signs of diabetes for over a year, and I've been in visits with his Burt Nash provider who just brushes it off and says, oh, well, he doesn't have health insurance, so he can't go see a doctor. We're not going to do a blood panel. Blood panels are necessary. Our patients, I think it's really, really important that if you are restoring someone to competency, that they have comprehensive medical monitoring when they receive psychotropics. And I think that you have to consider the fact that psychotropics are in fact very dangerous. They have a high incidence of side effects, many of which can become permanent once you take the medicine away. And what I see providers doing is a patient becomes compliant and manageable. So then the provider says, okay, it's great. And they don't care, and they are not interested in the damaging effects to their physical body or the permanent side effects that this may be causing. And I'm really hoping, because I'm talking about Burt Nash providers, that I can see more responsibility on the part of mental health providers to where they're paying attention to patients' medical condition. And I would hope that anyone restored in the jail or in the community doesn't only have access to Burt Nash mental health services, but also, very responsible and comprehensive medical monitoring. And unfortunately, someone can become compliant and also be physically damaged at the same time, and also psychiatrically damaged, because it's only externally that their symptoms are relieved, but internally they might not be able to mentally or emotionally handle their case. And so they might be compliant with their attorney even, but inside they're a mess. They might want to die. Okay. But the meds might stop them from hurting themselves and others, but they also might just not care anymore. So when you look at responsibly treating someone who's severely psychotic, this can take a long time, and that conflicts with speedy trial, because there are medicines like Lamictal, is a mood stabilizer that has a lot less damaging side effects. But it takes a month to even get to a safe dose that might work. So this kind of medical care can still take a long time. And I had a third concern about people released to the community. I attended a court hearing for a friend the other day. I just wanted to make sure he'd be okay, so I watched. And there were a bunch of guys standing up there for whom competency was an issue. Competency, either they were, I don't recall the specific issues, but I know who these people are. And if they were released into the community, I don't see them complying well with Burt Nash. And I would like to see safe housing for them. Because while someone may have what's technically safe, if that person is violent or abusive toward family, then going and living with their family might not actually be a safe option. So that's a concern that I would have about people who can be released to the community, but maybe can't really be trusted, that need something in between jail and release. So I hope I made myself clear. I really, my experience with jail healthcare is that I had some teeth that I no longer have. I had cavities, and a nurse looked in my mouth and she said, oh yeah, you got to have those pulled. Well, I got out of jail and I had dental insurance at the time, and I saw a dentist and he said, oh, we can fix all of those, and you can get a root canal. So I didn't actually follow up with that dental care, and now I'm missing those teeth, and I miss them dearly. So when I see people very flippantly telling you we have to remove your body parts, even if it's just teeth, I don't have a lot of faith. I worry, and I worry about people being administered medicines that can harm them if their healthcare is not very comprehensive. So I'm hoping that there would be additional more highly trained medical staff in the jail to monitor these people. I have seen people administered psychotropic medicine in the jail have seizures. So I think that it's very important to be honest about what these medicines do to people. Just like the sheriff was honest about what has to happen when you have to force someone to take medicine. We need to be honest with ourselves about what happens once they get that medicine, and what are we going to do about it, and how will we be safe and responsible. That's my big, that's all I had to say. And hopefully you can hear my questions and my concerns and respond to them. I'd like to know how you came up to the conclusion that there would be zero adverse outcomes from this. I'm not understanding how that would be.
Thanks, Ellen. Ellen and I have had an ongoing dialogue. Thank you.
Thank you for your
Pam,
input.
I'm going to move Rick into the panel.
Okay,
All right, can you hear me just fine?
yep.
Thank you. I appreciate a chance to kind of listen in on this meeting, especially appreciated Katie's report. I've been corresponding with Katie some about the competency issues. I have a number of follow-up questions, which I will direct to Katie via email, but I think the one that I really want to emphasize here in this meeting is, with all this work kind of pointing toward our ability to do competency restorations here, and regardless of whether they're done here or at Larned or Osawatomie, I think the issue remains about connecting back to the speedy trial issue that the judge and the DA were speaking about earlier. I think in my experience, there have been a number of cases where individuals have completed their competency restoration, and then they languish in jail. If they are refusing medication when they're returned to the jail, they're languishing there, decompensating. If the court proceedings cannot be scheduled very quickly, perhaps immediately upon their return, then we're kind of wasting our investment in the competency restoration process. We're wasting the individual's time and doing more harm. And so I think we have a special obligation in designing this system around competency to coordinate with the prosecutor, the defense counsel, and the court to make sure that that situation does not happen. So if the individual is restored to competency and is maintained on the medication while they're being held for trial, that's one thing. But for those who are not compliant upon their return, we got to get them in front of the court as quickly as possible. So I'll save my other questions for a follow-up with Katie, and look forward to your ongoing discussion on this issue. Thank you very much.
Thank you, Rick. Do we have any other members of the public?
I have a response to that, though.
Okay.
With our speedy trial, now that it's kicked in, I've instructed my office, all the prosecutors in our office have been instructed that we take the first available date the court gives us. So from our end, we're doing everything. We don't want any time assessed to the state for those reasons, and obviously to move cases. So that's the marching order that I've given our prosecutors. And so I just wanted to answer Rick's concern from our end.
Thank you. Were there any other questions from the public, Robin?
I see no other hands, Pam.
Thank you. Does anybody else have anything you want to add today? I don't see anybody. So seeing none, we're gonna adjourn the meeting, and our next meeting, the CJCC, will be May 14th from 11 to 12:30 at this location. Thank you, everyone, for attending today.